In the matter of Ravi versus State of Punjab, Supreme Court, while setting aside the judgment and order dated 23 January 2019, passed by High Court of Punjab and Haryana, opined that the prosecution has completely failed to produce evidence to prove the guilt of the appellant beyond the shadow of doubt on the basis of circumstantial evidence. Rather, the evidence on record gives ample leverage for two conflicting opinions, and in such circumstances, the benefit of doubt has to be given in favor to the appellant. The appellant is not on bail as per reports on record. He was in jail, and as per custody certificate, he had been in jail for 6 years and 2 months as on 5th January 2021, meaning thereby that he is in jail for over 10 years of today. Accordingly, he was directed to be released from the custody immediately. The appellant accused Ravi had been convicted by both the courts below for the murder of his first wife Jamni by strangulation. The appellant was living in the village Mad, Amritsar, by constructing a jhuggi in an open space where he was working as a laborer. He used to live with his deceased wife Jamni, his second wife Soma, and two sons born from the first wedlock. They all had been living together as such for 12 years. The incident is of 22 August 2014. According to the case of the prosecution, China Ram, the brother of the deceased, lodged a zero FIR at the police station Rajgarh, district Chudu in Rajasthan, stating that his sister Jamni, with her husband, appellant, was living at Raya Mandi, Tehsil Baba Bakala district, Amritsar. On the night of 22 August, at about 11 p.m., she was murdered by her husband in connivance with the second wife. The husband of the deceased, the appellant, brought the dead body from the village Rayamandi to village Gujuvas in a truck. In the FIR, he also stated that his sister Rajo was residing in the neighboring jhuggi of the appellant, and she herself had seen the appellant committing the murder of the deceased by strangulating her with a rope, and he threatened her from disclosing anything about it to anyone. The aforesaid FIR was transferred to the police station Khilchi, Amritsar, and the dead body of the deceased was also taken there, where the memo of Panchnama was executed and postmortem was conducted. The Panchnama on record reveals that it was conducted at village Raya Mandi, police station Raya, Tehsil Baba Bakala, the place where the appellant was living in a juggi. The said Panchnama, apart from other things, records the marks of injury on the body of the deceased and reports that there were marks of ligature around the neck and mouth was open with tongue protruding outward. The postmortem report states that, in the opinion of the doctor, the deceased died of asphyxia caused by hanging, and there were ligature remarks on the neck. A perusal of the zero FIR reveals that it is a computerized FIR and is not in the handwriting of the aforesaid witness. It only bears his signatures at the relevant place on both the pages of zero FIR. The entire case of the prosecution was based on circumstantial evidence. Though the sister of the deceased Rajo is said to be an eyewitness, she had not seen the commission of crime. China Ram, the brother of the deceased, who had lodged the complaint, in his testimony accepted that her sister was married to the appellant and they were residing in Rayamandi. However, he was not aware of what actually happened on 22 August and stated that her sister died due to her illness. He categorically stated that the appellant was not responsible for her death. The sister of the deceased Rajo was also declared hostile, as she stated that there was no dispute between her sister and husband, the appellant, and that she died due to illness and breathing problems. Similarly, the cousin of the deceased, Deepchand, was also declared hostile, as he expressed ignorance to what had actually happened. Dr. Mohanlal Meena, in his testimony, stated that he had conducted the post mortem cross examination, in which this witness accepted that though the cause of death is asphyxia, it can be caused by chronic tuberculosis also, and that the appearance of ligature marks on the neck might be due to the long journey of the dead body from one place to another. He had also explained the possibility of the ligature marks on the neck to be on account of the long journey and not solely due to hanging or strangulation. The Inspector Amolak Singh, who carried out the investigation, simply stated that he had conducted the investigation and arrested the appellant. On appellant disclosure, he discovered the rope which was used in the commission of crime. However, in cross examination, he admitted that similar ropes were easily available in the market. The court referred to a leading case of Sharad Birdichan Sarda versus State of Maharashtra, in which Supreme Court had laid down five golden principles, the punch shields of circumstantial evidence, namely, the circumstances from which the conclusion of guilt is to be drawn should be fully established. The facts so established should be consistent with the hypothesis of the guilt and the accused, that is to say, they should not be explainable on any other hypothesis except that the accused is guilty. The circumstances should be of conclusive nature and tendency. They should exclude every possible hypothesis except the one to be proved. And there must be a chain of evidence so complete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused, and must show that in all human probability the act must have been done by the accused. Court also referred to the judgment in Anis versus the state government of NCT, and it elaborated considered the principles of law governing the applicability of section 106 of the Evidence Act, and held that the court should apply section 106 of the Evidence Act in criminal cases with care and caution. The ordinary rule, which applies to the criminal trials and places the onus on the prosecution to prove the guilt of the accused, does not in any way stand modified by the provisions contained under Section 106 of the Evidence Act. The said provisions cannot be invoked to make up the inability of the prosecution to produce the evidence of circumstances pointing to the guilt of the accused. The said provisions cannot be used to support a conviction unless the prosecution has discharged the onus by proving all elements necessary to establish the offense. While allowing the appeal, the court also recorded appreciation to the valuable assistance rendered by the legal aid counsel, Miss Sonia Mathur, senior advocate, who had appeared for the appellant, and ably assisted by the learned counsel, Miss Surbhi Bhardwaj.